These are the two ways: a challenge for cause and a peremptory challenge. A challenge for cause is a way to remove a potential juror because of some intrinsic bias. This might be that the juror knows the judge or knows the opposing party, or has some characteristic which prevents a just or a capable verdict. For instance, the person isn't all there, hyped up on drugs, or some other handicap that will prevent a just verdict, or may have, to a lesser extent, profound religious beliefs that prevent the juror from issuing a verdict. Some religious beliefs that prevent judging. Challenges for cause are unlimited. Each attorney has an unlimited amount of challenges for cause. That being said, challenges for cause has a pretty high threshold that it needs to overcome. It's not just going to be simply, oh, look at how the juror is looking at the defendant. It's obvious that he doesn't like the defendant. Those sorts of challenges will be under the peremptory challenge. And state law and procedure usually limits the number of peremptory challenges. The peremptory challenges are challenges that the attorney just doesn't quite feel that that juror is a good fit. They don't really need to give a reason. They just can say, no, juror number 5, I don't like. He's looking at the defendant in a weird way. And peremptory challenges are usually limited to just 1 or 2, depending on the state law. While the challenge for cause, there is no limit, but there is a threshold to provide a reason that can be used to kick the juror off. Once you run out of peremptory challenges, that's it. You're out of luck. Now, just one more word about peremptory challenges. Peremptory challenges cannot be used to get rid of a class of people. For instance, if the defendant is of a certain nationality, then a juror, or I'm sorry, an attorney can't pick and choose all the other nationalities to get off the panel. That would be looking for a specific class to sit on the jury. The same thing goes for race or gender. The peremptory challenges cannot be used to mold the jury into a male only or a white only type of jury. Once the jury selection is complete, each attorney gets their shot, and I should focus on the types of questions that can be asked. It's pretty much fair game. The voir dire itself is pretty broad. I'm going to post a video from YouTube on a mock trial where someone is doing jury selection, and you can see the broad types of questions that can be asked. In a defamation action, for instance, I might ask the jury, has anyone ever been defamed before? And if someone raises their hand and For the defense, I'm probably going to use my peremptory challenge against that person, because I'm assuming that the person who was defamed, if it's just one person and I have enough peremptory challenges left, I'm going to assume that the one that's been defamed is less likely to hear my side of things and is more likely to prejudge the defense's side. I could ask, that would be a question asked to the whole jury, or I can ask a question to a particular juror. Let's say I see someone kind of fiddling a bit, and I say, or I would ask that juror, are you comfortable sitting, this might be a 2 or 3 day trial, do you think you're going to be able to sit through this and listen to the evidence? I notice you're not really paying attention and you're kind of jittery. And if she says, no, I don't have a very long attention span, it might be very difficult, that might be a challenge for cause. I would go up to the judge and request the removal of that juror. Now, the opposing attorney can also come up to the judge and say, Your Honor, this isn't a challenge for cause. If he wants to use his peremptory challenge, he can do so. But, I mean, being jittery, that's not quite a good argument for getting a juror off of the panel. I think he just doesn't like that she had a brother who was defamed, or something to that extent. So there's an argument that goes back and forth, and the judge ultimately is the decider whether or not the challenge for cause is going to be granted or a peremptory challenge will have to be used. So that's jury selection. Now we'll move on to opening statements. Actually, before opening statements, I want to mention motions in limine. A motion right before the trial starts, right before opening statements, the judge will ask if there are any motions in limine. What the judge is asking is there anything in the trial that parties want to stipulate and agree to? Or is there anything in the trial that one party wants to make sure doesn't get entered into the record? You can kind of consider this as protection ahead of time. If, for instance, we had talked about in evidence instances where evidence might be entered into the record that is just unduly prejudicial, but the actual objection may not come till after the fact, and then the request to the judge will be to strike it from the record. Well, the damage has already been done. The jury has already heard the profoundly prejudicial information. It's not going to be easy for them to listen to a judge telling them to strike it from their memories. It doesn't work that way. So what an attorney might do is request a motion in limine to prohibit the request for testimony of that information. It's asking the judge ahead of time to make a ruling so that there is no slip up and that information isn't brought forth. On the other hand, there may be information that an attorney knows to be true and knows would be allowed into court, and because of that doesn't want it said in court, or at least testified to emotionally. Those would usually be stipulated. So if, for instance,